Good morning, everyone. We are the Group 7, and today we're going to discuss the Republic Act number 11232, the Revised Corporation Code of the Philippines, Title 4, Title 5, and Title 6. Title 4, Powers of Corporations. Title 4 Power of Corporations consists of 10 sections and to be reported by Luella Salvo through virtual presentation. Section 35, Corporate Powers and Capacity. In Section 35 of the Corporation Code states that corporations have the authority to initiate legal proceedings using their corporate name. They have also perpetual existence unless stated otherwise in their certificate of incorporation. Corporation can establish a corporate seal and modify their articles of incorporation. They have the power to create and amend bylaws within legal boundaries. Stock corporations can issue or sell stocks, engage in transactions involving real estate and securities, and make contributions for charitable cause. They can also create benefit plan for employment and exercise other important powers. However, foreign corporations are not permitted to donate to political parties or participate in partisan political activities. Section 36. Power to extend or shorten corporate term. In Section 36 of the Corporation Code states that a private corporation can change its term as specified in its article of incorporation. This change must be approved by the majority of the board of directors or trustees and ratified by a meeting of stockholders or members representing at least 2/3 of the outstanding capital stock or membership. If a stockholder disagrees with the decision, they have the right to request an appraisal under certain conditions. Section 37. Power to increase or decrease capital stock, incur, create, or increase banded indebtedness. In Section 37 of the Corporation Code states that a corporation must obtain approval from the majority of the Board of Directors and 2/3 of the outstanding capital stock during a stockholders meeting if it wants to increase or decrease its capital stock or create banded indebtedness. It is important to note that Commission's approval and sometimes the Philippine Competition Commission's approval is necessary for any modification to a corporation's capital stock or the decision to increase banded indebtedness. Once the Commission's approve and issues its certificate of filing, the capital stock of the corporation will be considered increased or decreased and may authorize banded indebtedness will be incurred, created, or increased as declared in the certificate. The Commission will only accept a certificate for an increase in capital stock if it is accompanied by a sworn statement from the Treasurer showing that at least 25% of the increase has been subscribed and that at least 25% of that subscribed amount has been paid in cash or transferred as property of equal values. Section 38. Power to deny preemptive right. According to Section 38 of the Corporation Code, stockholders in a stock corporation have the right to subscribe to new shares based on their current shareholdings unless the articles of incorporation explicitly restrict this right. However, this right does not apply to shares issued through public stock offering or minimum stock ownership law. The issuance of shares without invoking this right is allowed if 2/3 of the stockholders approve it for acquiring necessary assets or setting previous debts. Section 39. Sale or other disposition of assets. In Section 39 of the Corporation Code states that a corporation has the authority to sell or dispose of its assets with approval of majority vote from its board of directors or trustees. However, if the transaction involves selling all of the corporation's properties, assets, and goodwill, at least 2/3 of the outstanding capital stock or members must approve in a meeting. For an stock corporation, a majority of trustees can authorize transactions. Once approval has been obtained, the board can decide to abandon property dispositions without seeking further action from the stockholders or members, considering any third party's right. However, it is important to note that this provision doesn't limit the corporation's ability to sell, lease, exchange, mortgage, pledge, or dispose of its property in the course of the regular business or for ongoing operations. Section 40. Power to acquire own shares. And Section 40 of the Corporation Code grants stock corporations the power to acquire their own shares subject to the conditions of having sufficient accumulated earnings. This authority is given for the legitimate corporate purposes, which including eliminating fractional shares resulting from stock dividends, resolving outstanding debts to the corporations from unpaid subscriptions or delinquent shares, and compensating, dissenting, or withdrawing stockholders. These actions are beneficial for the corporation's interests and help fulfill legal obligations and proper business practices. Section 41. Power to invest corporate funds in another corporations or business or for any other purpose. In Section 41 of the Corporation Code states that a private corporation can use its funds to invest in another corporations or businesses or for any other purpose, as long as it is approved by the majority of the board of directors or trustees and ratified by the stockholders representing at least two-thirds of the outstanding capital stock. For non-stock corporations, the approval should come from at least two-thirds of the members. These provisions allows private corporations to diversify their investment and pursue different goals beyond their primary purpose. The dissenting stockholders have the right to an appraisal if they do not agree with certain decisions made by the corporation. However, the right does not apply if the investment being made by the corporation is deemed reasonably necessary to achieve its primary purpose, as stated in the article of incorporation. In such cases, the approval of the stockholder or member is not required. Section 42. Power to declare dividends. In Section 42 of the Corporation Code outlines the authority of the Board of Directors to declare dividends for stockholders. Dividends can be paid in cash, property, or stock depending on the board's decision. The amount of the dividends is determined based on the number of the shares held by each stockholder. It's important to note that if a stockholder has unpaid subscriptions payment, their cash dividends will be used to cover this outstanding payment and associated costs. Stock dividends will only be distributed once all unpaid subscriptions have been paid in full. Additionally, approval from stockholders representing at least two-thirds of the outstanding capital stock is required for any issuance of stock dividends during a regular or special meeting. The stock corporations cannot keep surplus profits that go over 100% of their paid-in capital stock unless certain conditions are met. These conditions involve getting approval from the board of directors for expansions projects, having a loan agreement that restrict dividends declarations without consent, or when there are special circumstances requiring a reserve for unexpected events. Section 43. Power to enter into management contract. In Section 43 of the Corporation Code outlines the requirements for a corporation to enter into a management contract with another corporation. Approval is necessary from the board of directors and the majority of stockholders holding outstanding capital stock. Non-stock corporation need permission from a majority of members in both the managing and managed corporations. In certain cases where stockholders with the same interest own over one-third of voting stock or the majority of the board of directors in the managing corporations, also from the majority in the board of directors of the managed corporation, approval from the stockholders in the managed corporation, including thirds of the voting stock, is required. These regulations applies to contracts where one corporate oversees or conducts business on behalf of another corporation. This can be referred to as a service contract or operating agreement. The purpose of this regulation is to discuss the durations of contracts related to natural resources and management, while most contracts have specific time limits. Contracts involving natural resources activities can have extended duration as allowed by the law. However, management contracts are limited to a maximum term of 5 years for each period. Section 44. Ultra-Vires Act of Corporation. In Section 44 of the Corporation Code explains that corporations are not allowed to engage in activities that are not explicitly granted to them in the code of their articles of incorporations. However, they are allowed to engage in activities that are necessary or arise as a result of the powers that they have been granted. This limitation is important to ensure that corporations operate within their authorized boundaries.
Title 5. Bylaws. Title 5 consists of 3 sections, which will be reported by Anala Shane Dominic L. virtually.
Title 5 Bylaws. Section 45 Adoption of Bylaws. The adoption of bylaws by a corporation requires the affirmative vote of stockholders or members, and they must be signed and kept in the corporation's principal office. A copy of the bylaws certified by a majority of directors or trustee and countersigned by the secretary must be filed with the commission and attached to the original articles of incorporation. Bylaws may be adopted and filed prior to incorporation but must be approved and signed by all of the incorporators and submitted to the Commission. Bylaws are effective only upon the Commission's issuance of the certificate that they are in accordance with the Code. The Commission cannot accept bylaws or amendments from special corporations governed by special laws without a certificate from the appropriate government agency stating that they are in accordance with the law. Section 46 Contents of Bylaws. A private corporation can establish bylaws outlining the time, place, and manner of conducting meetings, notifying stockholders, determining the required quorum, attending and voting methods, proxies, directors' qualifications, duties, responsibilities, compensation guidelines, and the maximum number of independent board representatives. Bylaws also outlines the annual election of directors or trustees, the election or appointment of officers other than directors or trustees, penalties for violating bylaws, and the manner of issuing stock certificates. Additionally, the bylaws may provide arbitration agreements for matters pertaining to good governance in anti-graft and corruption measures. An arbitration agreement may be provided in the bylaws under Section 181 of the Code. Section 47 Amendment to Bylaws. The Board of Directors or Trustees can amend or repeal bylaws at a regular or special meetings, with the owners of at least a majority of outstanding capital stock or member of a non-stock corporation delegating the power. However, this power is revoked when stockholders owning or representing a majority of outstanding capital stock or members vote at a meeting. Any amendments or new bylaws may be attached to the original and certified by the corporation secretary and a majority of directors or trustees.
Title 5 Meetings. This is to be presented by Mabel A. Varela.
We are now with the Title 6, which is the meetings. So this pertains to meetings that are held, or kinds of meetings that are held for trustees, stockholders, directors, and members. And this meeting can be a regular or special meeting. And of course, this meeting is held for a purpose. I've mentioned that meetings are held as a regular or special meeting. So when we say regular meetings, they are held annually on a date fixed by the bylaws. If not, they can fix any date after April 15 of every year. So in order for this to happen, a written report shall be sent to all stockholders or the trustees or the members of the corporation at least 21 business days or 21 days prior to the meeting that is scheduled. And it should be also sent through online or electronic communication and other terms or communications that is allowed by the law. So of course, by doing a regular meetings, there should be some rules or guidelines to be followed. So minutes of a previous meetings, which include a description of voting and the vote tabulation that is used for the previous meeting, and a description of the opportunity given to the members to ask and record the answer given by them, problems and solutions, votings of the agendas, dividend policy, directors' profile and their backgrounds, an attendance report, a compensation report, self-dealings, and party transactions. And lastly, the profiles of directors nominated and those seeking for re-election. So we cannot avoid that one in holding a regular meeting because there might some changes that will happen, and some might want a re-election, or some might want have a new position, something like that. So they can also include any other matter on their regular meetings, such as the stock or the expansion of the business and many more, and other items. So the next one would be the list of non-stock and stock corporations and material information with voting rights, a detailed assessment of corporations' performance, a financial report of the preceding year, an explanation of dividend. Of course, if there's some postponement to be happen, members must be notified at least 2 weeks prior to the scheduled date of the meeting. So every meeting, whether it is a regular meeting or a special meeting, it should be held at the principal office of the corporation, and if not possible, it can be held in the city or municipality where the principal office is located. And a notice shall be sent through electronic communication, and each notice must contain the agenda of the meeting. So a proxy if ever a stockholder or a member cannot made it possibly there, they can also appoint have their proxy, provided that they have submitted the requirements to the secretary and procedures to be followed. And all the proceedings and transacted during that meeting shall be valid, provided that all the members are present. So quorum. So the quorum shall consist of the representation of the majority of the outstanding capital stock or the majority of the members in the case of non-stock corporation. So as we all know, trustees and stockholders shall constitute a quorum to transact in a corporate business, and every decision reached by them must also constitute a quorum. So when it comes to regular meetings of the board of directors, they will be held monthly. In terms of special meetings, they may be held at any time if necessary or upon the call of the president. So unlike with members, meetings of directors and trustees may be held anywhere in or outside the Philippines. A notice of stating the date, time, and place of the meeting must be sent to every director at least 2 days prior to the scheduled meetings, and this can be waived and either expressly or impliedly. So directors who cannot physically attend or vote can send their vote through remote communication, such as video conference and many more that is allowed by our law. But we shall bear in mind that directors cannot attend or vote by proxy at the meetings. So who shall govern the meetings? Of course, it should be governed by the chairman, and in his absence, the president shall preside over all meetings of directors and members. So if a stockholder grants a security in his stock, the stockholder grantor shall have the right to attend a vote at meeting of stockholders. So any representative duly appointed by court may attend and vote in behalf of stockholder without any proxy. So if we have a joint ownership and stock, co-owners shall have shall be necessary in voting on shares of the stock, meaning vote of the consent of the parties must be given, unless there is a written proxy signed by all the co-owners authorizing one person to be their proxy. So in terms with our treasurer shares, there is no voting right as long as a shares remain in treasury. In the matter of voting and meetings held, of course, a stockholder, member, or proxy may vote. Also, voting can also be done through remote communication, just in case the member or director cannot attend physically. However, a member should be present in quorum. If there will be a proxy, it should be properly signed and documented by the owner and should be received by the secretary. In the matter of voting in meetings held, of course, a stockholder, member, or proxy may vote. Also, voting can also be done through remote communication, just in case the member or director cannot attend physically. However, a member should be present in quorum. If there will be a proxy, it should be properly signed and documented by the owner and should be received by the secretary. The stockholders of the stock corporation may create a voting right for the purpose of conferring on the trustee the right to vote within a period. A voting trust may be for a period of 5 years if required in the loan agreement, but it will automatically expire once paid. So the loan agreement must be in writing and notarized and certified true copy must be submitted to the commission. Otherwise, it is unenforceable. So the trustees deliver to the trustees the voting trust certificates, which are transferable in the same manner. The trust agreement shall be examined by any stockholder. And also, a stockholder may transfer some shares to the same trustee following the terms and conditions of the trust agreement. So, no voting trust agreement shall be entered into for the purpose of perpetuating fraud. And finally, all rights granted in voting trust will expire unless renewed. So, once renewed, a new certificates of stock shall be issued in the name of the trustors. Thank you.